things for you to consider when writing a will, Part 1. Last 2 weeks, we talked about the basic estate planning. This week, let's learn about will writing. Hi, I'm Eva Wong here, your wealth coach to achieve early retirement. If you wish to learn how to become financial savvy and to retire early, remember to subscribe to my channel here. You understand now, will is to distribute one's estate when one dies. But it doesn't mean that having a will, it will solve all the estate planning issues. It will only when the will writing process is done properly. So, I'm going to share with you there are several things for you to consider when you are writing a will to have effective distribution of estate. First, you need to understand how many will do you need. Firstly, know your permanent residence place. If you are working and living in Malaysia, Malaysia definitely will be your permanent residence. Then, identify your assets. Whether you own any foreign assets such as properties outside Malaysia, shares and paper investments held in foreign brokerage accounts, or even having any company in foreign country. This is because the law governing the will for different countries is different. In order to validate your will overseas, your executor will need to reseal the grant of probate in a court of the foreign jurisdiction. So to avoid all these complications, if the value of the asset in foreign country is high, you might need to set up separate will in that particular foreign country. Of course, you can always include the foreign assets in your Malaysia's will, but it could be a bit complicated. Second, the executor. Executors are the personal representatives responsible for administering the estate of the deceased. According to the Wills Act in Malaysia, we can appoint anyone who is 18 years of age or older to act as the executor with up to maximum 4 executors. Instead of individuals, one can also appoint a trust corporation as the executor. For me, executor is a very important position. I personally feel that it should be someone who is capable and experienced enough to administer the estate. Even though many people think that their spouse can be the executor, personally, I think a trust corporation is at a better position to handle this. When one passes away, the spouse will be the one handling the most issues such as the funeral, cleaning up the deceased personal stuff at home, and etc. Why burden the spouse again with the administration of the estate? So, having someone who is independent like good friend or a trust corporation can be a better choice at that time. Also, remember to have second choice and third choice of executor in case the first choice renounces the right or does not survive. Also, remember to consult and inform all the named executors before putting their names in the will to make sure they are okay with the arrangement. Third, guardian for young children. If we are having young children, this needs to be considered properly. Upon the death of a parent, the surviving parent can become the child's sole guardian. However, if the deceased parent appointed a guardian, the surviving parent and such an appointee will be the joint guardians. If you think that your spouse cannot handle the kids properly, it's better to appoint a guardian to have joint guardianship for your kids. Consult the person before writing his or her name in the will to avoid problem. Of course, for third-party executor and guardian, do remember to allocate some monies or allowances for them. If they are not being paid or paid well, they might not be able to execute their duties well. For trust corporation, it will definitely charge for its service. Are the first 3 things to decide when you first write your will. Stay tuned to part 2 next week. That's all for my sharing this time, and thank you for watching this video, and I do hope that you like it. Comment below what have you learned from this video, and do subscribe to my channel for more early retirement tips and finance tips. And I will see you again next week. Bye!